we have two pieces of legislation in Botswana when we're talking about intellectual property. We have the Copyright and Neighboring Rights Act, and then we have the Industrial Property Act. Specifically for today's presentation, we are going to be looking at the Copyright and Neighboring Rights Act, because that is what governs performance arts, that is what governs artistic and literary works. So it is defined within the definition of the definition sections of the law that this act applies to artistic and literary works, and then inclusive of performances. And those performances include, dramatic performances, they include musical performances, they include any variety act or similar presentation, any literary or dramatic dramatic adaptation of a literary work, or any mode of audio, visual, or acoustic presentation. So there's a very, very broad scope of what can constitute a performance, insofar as it involves the deployment of the human body to convey a certain artistic message or a certain artistic product that can qualify as a performance in terms of the Copyright and Neighboring Act. So for example, me standing here today, technically could be a performance, because I am, employing my body to deliver something for you as an audience. And one of the things that is important to understand is that not everything is copyrightable. There has to be a certain threshold that is met where the thing is said to be qualifying as a work in order for it to meet the standard. So it has to be a book you've written, it has to be a play you've performed, it has to be a song you've written or a song you've produced. There's certain things that end products that constitute as work in terms of the Copyright Act. However, there's also the recognition that certain people make certain contributions to the final product, even though they themselves cannot be deemed to be the authors of the work. And in terms of legal terms, when I say author, we don't necessarily mean a writer, we mean the person who created the work. So if it's a song, the author of the song would be the songwriter. If it's a painting, the author of the painting would be the painter. So it's the person who is responsible, or whose work it is that was created. So the law recognizes that certain people make certain contributions, but they're not necessarily authors in legalistic terms. So if you're performing a play, for example, you are engaging in a dramatic adaptation of somebody else's work. That means that somebody else has authorship over it. So there has to be a scope of rights that you are given in order for you to be able to have some kind of, of benefit from it. Because at the end of the day, you yourself have put in some creative effort, some creative labor, even some financial effort as well, to produce this work. And then there's that for works, and then there's what we call derivative works. Derivative works are not necessarily original works, but are largely original compositions of pre-existing works, or original adaptations of pre-existing works. So for example, if you wrote a book, and I make a Setswana translation of the book, my translation is the derivative work, and then your book is your work. That means that you still have all the copyright and intellectual property rights in your original work, but I also have intellectual property rights in respect of the derivative work. So a lot of the conversation that we're going to be having today is going to be, how do we manage these relationships, right? How do we manage the intersection of your rights with somebody else's rights? And what does the law say about that, and how can a contract help you with that? So these are some of the examples of derivative works. These are translations, adaptations, arrangements. Arrangements even to the extent that a phone book, for example. I know there was, when we were in law school, there was a famous case of, I forgot the name, but the idea is somebody made a phone book. You know when people still had phone books? Not like the app on the phone. I'm seeing the kids born in 2011, what is a phone book? We used to write people's numbers in books. There used to be a big book that you buy that had everyone's number in it. So the arrangement of that, those names, those numbers, that is information that is freely available, that is publicly available. But your specific arrangement of that information constitutes it to be a kind of work. And that principle applies across the board. So, for example, one of the things that I'm going to start moving around, I don't know. One of the things that copyright applies to is choreography. I remember some years ago, there was My African Dream, and I remember in its heydays when what is it called? No Reason. There is my sister. Give it till it for no reason. When that was installed, you'd have the guys getting on stage and everybody started the same way. You go, everybody started the same way. Now, you can't really say, I have copyright over that, right? But the way in which you arrange it with other movements and with other elements makes it a new work. Makes it a kind of transformation or modification of somebody else's work, and therefore it qualifies as a copyrightable derivative work. So you can actually say, this series of movements, as I've arranged them, is my copyright, and therefore I am able to enforce that copyright. Another example, of course, collections of works, databases. We've already touched on the phone book example there. And then collections and expressions of folklore, provided that such collections are original in terms of their selection. So we grow up, Punalemaina, Nichiwele, and all of them. Nobody has copyright over that. But if you were to take those works and arrange them in a singular work in a specific way that is unique to your interpretation, so for example, you write a book and right? So that specific arrangement becomes a derivative work, specifically when you're dealing with expressions of folklore. And guys, I need you to create expressions of folklore, guys. I really, really like because once we lose these stories, it's going to be hard to get them back. So I hope that one of the things that you are taking away from today's exercise is, how do we document these stories? Ryan will touch more about that. He knows more about that than I do. Before we get actually into neighboring rights, I think it's always important to understand what copyright allows you to do. Because copyright is your ability to say. So it's a bundle of rights, first of all. It's a bundle of rights that give you the ability to say, you can do this with my work, or you can't do this with my work. So you can authorize or object to the adaptation of your work, the reproduction of your work, the sale of your work, etc., etc. This is a bundle of rights that we then collectively would call copyright. So it's the ability to say, I want this to be sold at this place at this time in this manner. Or I do not want this to be sold in this place at this time at this manner. Or I want this to be translated by Samamang at this place in this manner. Or I do not want that to happen. Or you can say, I don't want you to take my product out of Botswana, because importation is also one of the things that copyright deals with. I want my product to strictly be in Botswana and not beyond the borders of Botswana. Or I want my product to be able to be taken beyond the borders of Botswana. That's a right that you have as a copyright holder. The importance of copyright is that it gives you control and ownership over your work. The idea being that because you have expanded or you've spent intellectual labor, financial labor, and all these other resources, the law should give you something that allows you to recover those costs. Baby, it's a ROI. They call it return on investment. So the law should be able to allow you to have a return on investment by giving you a monopoly over what you've created. So it's you and you alone who is the creator who can exercise those rights. If you've created the work in collaboration with another person, depending again on your contractual relationship, which we will get to, it's you and that person. And this is not an unlimited right that goes on forever and ever. Your work is protected for the period of your lifetime and then for 50 years after. The idea being that at least 2 generations after you should be able to benefit from your work. So it's not only a thing of how do I make money today, it's also a thing of whatever the law allows me to make money from today is also something that can benefit my children. It's also something that can benefit my children's children, right? So when you are planning around the management of your intellectual property rights, these are some of the issues to be considered. I always see people talking about writing a will nowadays. Copyright is something that you very much put in your will to say so-and-so shall have the rights to these 1, 2, 3 aspects of my work. So neighboring rights then come in to solve that question we spoke about earlier, to say there are people who are involved, but they're not authors in the production of the work. These can be businesses, these can be individuals. So neighboring rights then are provided for the protection of the legal interests of certain persons or legal entities who either contribute to making the work available to the public or produce subject matter which will not qualify as works under the general understanding of copyright, but who nevertheless express creativity or technical organizational skill sufficient to justify recognition of their contribution as deserving of protection.